Good morning, Mr. Maidman.
Good morning, and if it please the court. I would like to address the issue relating to the footprints, the photographs of footprints in the snow first, and then spend whatever remaining time I have on the CIAMPA instruction. In this case, there was a delay in the disclosure, at least allegedly a delay in the disclosure of footprints in the backyard of the crime scene. There were footprints that went from the back of the house through the backyard and towards the street where one of the alleged victims sought help from another
Didn't the judge, though? Didn't the judge, when the issue got raised, say they cannot come? That the Commonwealth certainly can't introduce these unless and until it is clarified that they were disclosed before trial?
Did he say? Yes, he did.
Okay. And wasn't it the defendant who introduced them?
Yes, but you have to go back in time before that. The defendant went through 3 police witnesses where he asked each of these witnesses. Basically, the Commonwealth got up and asked questions about footprints in the snow. Defense lawyer gets up and cross-examines each of these police officers and says, well, was there anything in your police report about footprints in the snow? And this goes on over pages of testimony. And they all say, I saw the footprints, and I told some other state trooper to take photographs from the crime scene services group. But there was, this lawyer was made to look, say it politely, incompetent, but probably silly. And then the Commonwealth walks up and says, and introduces the photographs. And 3 lawyers get up and say, I never saw those in my life.
I'm sorry, they introduced the photographs? Meaning
They sought to introduce.
They sought, that's
Did the jury see the photographs?
No, but they heard descriptions of the photographs, or identification, foundational evidence, I'll call it.
Okay,
This was on the 3rd day of trial?
It was over 2 days of the trial. I want to say the 2nd and 3rd. I know that there's an intervening day.
But if
I'm sorry. Excuse me. It happened one day, and then the next day the photographs were introduced. I'm sorry, Judge.
If the defense counsel had not changed his position, the same attorney who you claim to be foolish could have argued to the jury that the police officers, despite all the photographs that were taken, that the jury did not see a single photograph of the footprint. He had that opportunity. He gave it up by offering the documents himself.
Based on my reading of the transcript, based on what I would call a fair reading of the transcript, I don't think that's possible. I think that there clearly was testimony about the footprints in the snow, and there was testimony about how this individual jumped out the back window and then over to the next street through the snow. Okay.
Well, help me to understand why the defense attorney then offered the photographs himself. There clearly was some benefit that he saw in that. What? Yeah.
There was the benefit was, and it's in his affidavit, which is in my record appendix. There was one photograph of a roof, what I'll call a roof, where the person jumped out the bathroom window, and the issue was there scuff marks on the roof? Were there footprints in the snow on the roof? Turns out there was no snow on that roof. At least that's why he introduced it. But you have to go back and try to picture how this lawyer looked. This case was about credibility, about the credibility of the Commonwealth's primary witness, essentially the only major witness, the guy who was there, allegedly a victim, and then there was essentially the credibility of the defense lawyer. Defendant didn't testify, and this guy is made to look really bad. And then let me point out else. If you take a look at what the Commonwealth in their brief call it a sanction, I mean I think that's being. I would not characterize it as a sanction. Essentially, he said, he made an emotion. He reduced this all to writing with an affidavit. I mean, this was a big deal in the trial. For him to go put this together with the exhibits of what was.
Were all 3 defendants joining in this?
I want to say yes, but I'm not sure. I know they all got up and said, we never saw this before. And, and the Commonwealth never came, there's an issue, the Commonwealth raises an issue in their brief that, well, we do not concede that they didn't get the photographs. And I think, the clear inference. I mean, and then they say there was no fact-finding on this. Yes, there was no formal fact-finding, but I think that any fair reading of the transcript, that here you have 3 defense counsel all getting saying, we never saw this. So the question is, how do you try to ameliorate any harm that happened as a result of this? The prejudice that would flow from basically made looking silly in front of the jury. I mean, and then to top it off, and you have to keep the following in this context. In the closing argument, you've got 4 references to smoke screens. Lawyers putting up smoke screens. And here you have a lawyer who goes around asking questions which no competent attorney, whether constitutional or not, no competent lawyer would be asking these questions if he thought there were photographs of snow prints. So, back to what the...
Okay, but he asked the questions. He doesn't... I'm going to accept what you say. Okay. He asks the questions. He doesn't think there are photographs. The answers are, yeah, I told somebody to take photographs, but they're not there. And then the judge says, I'm not going to admit them. Why couldn't the lawyer have left it like that?
He felt that's unclear. I mean, I did not allege ineffective assistance of counsel with respect to this. He felt that he needed that there was a benefit to the using the picture of the roof with having no snow. He felt that it did impeach his testimony.
But having done that, I mean, isn't that an election that sort of
with respect to that photograph? He addresses this in his affidavit, and that is evidence in the record. That is something that's in the record on this. And he says, "I felt the jury already knew from the foundation being laid by the Commonwealth what was in the photograph. So I felt he had no alternative." But let me at least briefly talk about the quote unquote sanction.
Well, can I just back up for a minute and say,
yes.
If I assume that this testimony about the foundational testimony about the photographs came in the Commonwealth's examination of its own witness through the prosecutor's questioning,
True.
After having heard all this about the photographs, what's the explanation in the record as to why defense counsel started proceeding as if there were no photographs without first going to the sidebar saying, I never got any photographs?
That's an excellent question. There was nothing in any of the police reports about footprints in the snow. Okay, and I'm not. I have to go back and check the transcript. But my point is that the witnesses, the police officers, were asked about footprints in the snow, and the follow-up question on cross-examination was, "Well, there's nothing in your police report. That'd be pretty significant, wouldn't it be?" And they said, "Well, it's not there." And I'm not sure if they actually started talking about photographs or whether defense counsel asked, "Well, where are the photographs?" And police officer says, "Well, I told someone else to take photographs. That's not my responsibility of the crime scene." I'm not sure how that came out in the transcript. That's my point.
Could you just speak a little louder?
I'm sorry.
I'm having trouble hearing you.
Oh, I'm sorry. So I hope that answers that question.
But is your position that the trial court erred?
Yes.
And what should the trial judge what's he supposed to do? He has defense lawyers saying, I never got these photographs. Commonwealth says, I think I gave him all the photographs. The jury is sitting there. It seems as if he did all that he reasonably could do to say the photographs won't come in until I'm satisfied from the Commonwealth that they have indeed provided those photographs in discovery.
Justice Gantz, the request was, would you inform the jury that defense counsel did not receive these photographs until the Commonwealth attempted to introduce them into evidence? That was what the motion was. And I think it's baffling why the judge wouldn't go along with that. I don't think there's any question he didn't receive them. And the Commonwealth objected to that. And this is not what I would call a draconian sanction. I don't think it was a sanction at all. And we wouldn't be here today discussing that if that had happened.
And you think that the judge's not doing that is a reversible error?
I think in the overall context of the case, where the case turned on credibility, the credibility of the defendant, credibility of the defendant's lawyer, and compounded by closing argument where the trial court, where the trial prosecutor talked about don't be deceived by smoke screens, when this would ostensibly be one of those smoke screens. She didn't say that it was, but ostensibly the jury could draw its own conclusions. Think about what the jury, what must have gone on in the jury room. Here you have this going on, and then all of a sudden here's the pictures. And it called into question the competency of the lawyer. What was he trying to do? And unless you have any other questions, I'll move on to the second issue.
Thank you, Mr. Maitland.
Let me, as far as the CIAMPA instruction goes, as I mentioned, this case was turned on the credibility of essentially a single witness who was allegedly one of the victims of the crimes, and he. When he ran through the backyard to the opposite street and police show up, he said there were three masked men who came and invaded my house. And he kept that story up until he gets to the police station, when he literally wants to meet, and he does meet with the district attorney of Hampden County.
Right.
And who makes a deal with him and says, I will give you the truth if you'll get rid of my pending charges.
Well, he says, I'll give you the names of the people, right?
I think, well, I'm sure that's probably what he said, but what the jury heard, give the truth, and I cite that in my brief to that page.
That was in the closing.
No, I think that was the defendant's testimony. I'm sorry, that was Mr. Young's testimony.
That it was conditioned. His testimony was conditioned on something.
No, true. He did nothing about condition in the testimony. The cooperation in this case. It's an implied cooperation agreement. It's an implied agreement to give the truth. I don't think it can be read any other way.
And what if he didn't give the truth? What would happen to him, other than a perjury conviction?
Well, if he didn't give the truth at the police station, or if he didn't give
at the trial.
Well, if he obviously faces at least perjury, if that could be proven.
But nothing else.
Well, there is something else. I mean, these cases were null prost, or they were dismissed. Short of trial, all those charges could come back. Yeah. So to argue that this is all in the past, there were pending charges that were resolved, well, that is simply not true.
But the judge did give an instruction about his credibility, right? He didn't give the Champa language, but he did give an instruction about looking carefully at that testimony.
It was not. It certainly wasn't the Champa language, and it was a promises, rewards, and inducements type of jury instruction. It was not focused on. Commonwealth, the prosecutor has no knowledge of what is the truth. You should examine it with extreme caution. All the language from SIAMPA, which was the requested instruction, which it's in a footnote on my brief. It's best I can tell, it's a standard SIAMPA instruction.
But did the jury hear anything like they usually hear when somebody is testifying in accordance with a cooperation agreement, to the effect that I'm going to, I will get something in exchange for telling the truth, and I'm here to tell the truth?
Well, the argument was, the testimony is that he had his charges dismissed.
They heard that.
Oh, yeah.
I mean,
yes,
so they heard the transaction between him and the district attorney.
Yes, and he was given a ticket flight out of town,
But it was a past benefit.
Past benefit. That's the way it was characterized. I think that's the way it was characterized. And it obviously is not a past benefit, because the charges could come back tomorrow. If the Commonwealth did not believe that he gave truthful testimony, I guess they could try to indict him for perjury, but they certainly could re-indict him or file new complaints in the district court.
But was there any indication at trial that if he didn't testify truthfully, as determined by the Commonwealth,
no.
The charges would be revived?
No. I don't think there was anything about the revival of the charges in there. This is portrayed as the agreement at the police station. He got his benefit, and here he is today testifying as a good citizen.
So you're saying then that Chiampa is required even when there is no language to neutralize in a plea agreement, but simply because there is any agreement to cooperate, that requires the Chiampa language to be thrown in?
Well, it certainly seems to me that this was characterized it any way the court wishes, but it was a cooperation agreement, and where a cooperator received benefits for testifying. And I would add, it was implied that he was going to testify.
You mean at the
I mean, there was-
time, are you saying it was implied that he was going to testify when the district attorney, when they said, we'll drop the charges? I thought it was about giving the names of the three people.
It was.
But you're saying it was implied that at their trial, whenever that might be, he would testify?
I certainly think that implication is there. And I think, I mean, I'm not sure, don't know if this is in the record, but actually I think it is, that he came back to the trial at taxpayer expense.
Well,
And that was admitted in evidence, wasn't it?
I think so.
Yes.
Let me confront you with this argument and ask you to respond to it. Generally, judges don't volunteer to juries that DAs have no special knowledge as to the truth. It's not generally said to a jury in the absence of a plea agreement in which there is language which says if you do not tell the truth, these consequences will occur, and the jury knows that those consequences did not occur, and this language of Ciampa is designed to neutralize the language of that agreement. And since that language was not here in this agreement, that Ciampa was not required. Why is that not a sensible result here?
Because there was, because there was a cooperation agreement, there was a plea agreement. I mean, the plea was get rid of my cases. I mean, it had everything but. Let me try to answer it this way. The only difference between this case and the classic Ciampa case, at least as I understand it, is that they didn't have, well, A, there was not a written agreement, and B, they didn't hold it over the witness's head and say, sentencing is tomorrow. I mean, you're under indictment and your trial is next week. And so the defense counsel couldn't get up there and say, if he doesn't say the right things, he's not going to get a plea. But I think this is almost indistinguishable from the classic Ciampa type of situation. You have a cooperation agreement. You had the guy getting benefits. Had the guy being told he got benefits. I think I don't know what I really don't understand, and maybe this is the question the court has to address. How is the Commonwealth hurt by not giving this kind of instruction?
By giving it?
Yes, I mean from a due process standpoint, from a fairness standpoint.
Because the Commonwealth's actually not vouching. They're trying to get the vouching element out of. That was one of the purposes of Ciampa. It strikes me that one of the differences between Ciampa and the standard case is that in Ciampa the prosecutor has a leash, a metaphorical leash around the neck of the witness. It's visible. I mean, metaphorically visible. That's not true in other situations.
Yes, although it may have been true in this case.
What's the
because
metaphor?
The leash would have been, we can charge with all these crimes. We can re-indict you. We can refile the complaints. They haven't gone away. You may think they've gone away. But I mean, it's.
Isn't, I mean, what you're saying, it seems to me, is that in every case where there is a promise, reward, or inducement triggering that instruction, it really should be a Ciampa instruction. Especially
where, in a case like this one, where there's so much emphasis on giving the truth, and the issue is, well, am I going to tell? I'll tell the truth if I get my charges dropped. I mean, there's a lot of discussion about giving the truth in this case. But
it's about the identity of the other three, right? Was it also about the facts of what happened?
Sure. I don't think it was. I mean, obviously, you want to know the identity of the other two folks. But I'm sure that the police would want to know what happened in that house. I don't think it was just limited. Just tell us the names and we'll give you your deal. They wanted a statement from him, and they got a statement from him, 8-page statement.
Mr. Rabin, let me just go back to the photographs and ask you one very specific question. At the time that defense counsel did introduce the photographs, does the record indicate that he expressly withdrew his objection
Yes, he does say that.
Okay,
It's in the record.
okay, thank you.
He does say that. But, and I think, let me just close by saying this. I believe the motion was filed the next day, where he put, all the motion and the request for the instruction all happened the next day. And that has to be viewed in that context. And with that, I rest on my brief. Thank you.
Thank you, Mr. Maitland. Good morning, Mr. Townsend.
Thank you. May it please the Court. Thomas Townsend for the Commonwealth. Actually, the motion was 5 days later. The witnesses at issue here were the fifth and sixth witnesses of a trial which included 28 witnesses.
You mean the photograph witnesses?
The photograph witnesses.
Oh, I'm sorry, just say that again. We're 5 and...
Numbers 5 and 6
Of 28. Okay, yeah.
This was a very long trial, thousands of pages, thousands of questions asked in cross-examination, 164 exhibits. There were several days for jury selection. There was a snowstorm that delayed part of the testimony. So this was a long trial. When the defendant made this request, it was in a motion asking the judge to take judicial notice that the defendant had not received that discovery. And the judge said, I can't take judicial notice. Number one, it's not a known fact. Number two, it's not an open issue. It wasn't clear whether the defense had received those photos. When this issue arose, the judge said, the photos are going to be excluded. I want counsel at the end of the day to get their discs, bring them to the district attorney's office. The district attorney will put them on their computer screen and see if they're there. If the photos are there, the district attorney then would be allowed to introduce them as exhibits. If they are not there, they will stay excluded from the jury. Before that could even happen, the defendant chose to introduce the exhibits themselves. As it turned out, those photos were much more beneficial to the defense than they would have been to the Commonwealth.
I'm sorry to interrupt you, but Mr. Maiden said that the defense attorney introduced only one of a number. Did he?
I think he introduced all of the photos. And he introduced those photos. The Commonwealth had 3 different police officers testify to the footprints in the snow. So the photos would corroborate that testimony. An issue arose with the cross-examination of Officer McCain, who testified that there was a dusting of snow on the roof, and he could see some foot marks or foot scuffs on the roof, which would have corroborated Mark Young's testimony that he fled out the window. The defendant used those photos to show that there was no snow on the roof, thereby contradicting that testimony and adding substance to the defendant's claim, or the defense's claim made in closing argument, that Mr. Young actually exited out of the back door. He didn't exit out of the back window. The significance of that discrepancy I'm not too sure of, but it was a way to poke holes in the story provided by Mr. Young. Interestingly enough, the defendant never contradicted or never doubted that Mr. Young had run through the backyard. It's not that these, whether their existence or non-existence of these footprints were essential to the defendant's case. The defendant did not doubt and did not contradict that Mr. Young did show up to an elderly couple.
There were how many sets of footprints? 4?
There was a trail of footprints going through the back.
Of 4 different people, the 3 assailants, alleged assailants, and the...
No, what happened was after the shooting, the assailants fled out the front door. Mr. Young looked out the attic window, saw at least 2 of them going into a car. Wasn't sure. He suspected that if he went downstairs and went out the front door, he could be seen. So what he did is he went down to the 2nd floor, went out the bathroom window, and then ran across the backyard. So he is the only one who ran in that direction. He was running in the opposite direction of the perpetrators. He went to a street, the next street over, and was just banging on doors, trying to get someone to call the police to hopefully save his friends. So there was no contradiction. The defendant's theory was that Mr. Young freaked out. There was some sort of drug deal that had gone bad. He freaked out and ran out of the house. So the footprints were not really contradicted by the defense. It wasn't a key piece of evidence. And also the notion that there were pages and pages and pages of cross-examination by defense counsel is just not accurate. Actually, the defendant on his cross-examination of Officer Lockwood, the first officer to testify about seeing the footprints, there was 1 page worth of cross-examination about the footprints. That's page 75 to 76 on the February 15th transcript. Sergeant Rowland, on cross-examination, he asked 3 questions about the footprints. In our recross-examination of Sergeant Rowland, there's one page. The cross-examination is at page 190 and 191 on February 15th, and the recross-examination is on pages 220 to 221. So contrary to what defense counsel submitted in an affidavit, this was not significant cross-examination or pages and pages of cross-examination that he would look foolish in front of the jury for having cross-examined on that. And there's good reason to cross-examine on. He was attacking generally the police investigation of the case. There was no mention of the footprints in the police reports. There was no discernible footprints or identifiable footprints in the video of the scene. And he was actually, Sergeant Rowland, who was in charge of the scene, actually admitted that there were no footprints. And so it made him, if anyone looked foolish, it would have been the supervising officer in charge of the scene who would have looked foolish. And defense counsel had a remedy of self-help in closing argument. He argued to the jury that no one knew about the photographs until Officer McCain testified to them. So he provided the jury an explanation, if one was needed, to explain why he cross-examined, the brief cross-examination on these photographs. If Officer Rowland did not know about the photographs, defense counsel certainly can't be faulted for not knowing about the photographs.
And I take it the prosecutor didn't dispute that in his closing, or her closing.
No, there was no attempt to make defense counsel look foolish having to do with the cross-examination about the photographs. And of course, the overarching concern is there's no prejudice. The defendant did not dispute that there were photographs or there would be footprints in the snow. Defense counsel in his closing said he ran out the back door rather than coming out of the window. So the photographs would not have aided the Commonwealth, were not a key evidence in the Commonwealth's case. And actually, the use of the photographs by the defense to show there was no dusting of snow actually helped him more than could have helped the Commonwealth.
If they weren't key, you still had 3 police officers testify about that?
There were 3 officers who independently testified that they saw the footprints in the snow.
Was there an objection during the direct examination of the police officers, saying, I didn't get the photographs?
No, the first 2 officers testified that they saw the footprints, and they asked the photographer to, take pictures of them. Photographs weren't introduced then. It was when Officer McCain, the 3rd officer, who was testified on a different day, the photographs were sought to be introduced in his testimony, and at that point there were objections from all defense counsel. Then after the defendant's counsel used the photographs and introduced the photographs himself, all counsel withdrew their objections. And the trial judge said, well, that pretty much takes care of that issue. No need to bring in the discovery to see if they were provided or not.
I'm trying to understand the importance of how Mr. Young left. Was there any claim that Mr. Young himself had done the murder?
Not by the defendant's attorney. The defendant's attorney's theory was that the defendant himself was a 4th victim. He was a victim himself. He had a gunshot in his hand. And that perhaps there was some sort of drug deal had gone bad. Mr. Young freaked out and ran out the back door. He initially lied about there being masked invaders because he was still afraid that the perpetrators would get him if...
So the claim is that Young was failing to reveal the true shooter.
Because he was afraid. And he threw the defendant under the bus, who was his friend, Mr. Felder, and invented 2 other people to have been his accomplices. There was a lot of evidence against this defendant, including DNA evidence and multiple identifications, so he made the best of a situation.
So it was that all defendants were a figment of Mr. Young's imagination because the real culprit hadn't been caught. He wasn't going to give him up.
The real culprits, plural.
Culprits.
Mr. Felder had to acknowledge he was present, his DNA was there, unless he wanted to challenge the DNA evidence. So, in retrospect, Mr. Young, I don't know. It's not clear. I mean, the closing arguments are an interesting read, trying to, determine what Mr. Young's motives were. Why would he sell his friend, throw him under the bus, Mr. Felder, but invent 2 other people? All 3 defendants were found with the money that was stolen. Each had roughly a third of the $20,000 on their person. with a distinctive black rubber bands. It was a lot of evidence against all the defendants. The strongest evidence was against this defendant because of the DNA evidence and the multiple identifications. Not just Mr. Young, but Mr. Young's girlfriend identified the defendant, having seen him in front of the house. The woman who, Mr. Lewis's girlfriend, who handed over the gift bag containing the $20,000, she identified the defendant as the person who received the bag. And that's certainly strong evidence. And, of course, the defendant had $7,000, which were wrapped in $1,000 increments with black rubber bands, which is, as Mr. Lewis's girlfriend testified, that's how they wrapped their money, and that's how they had it bound. And also, when he was arrested, when he went to report to the hospital shortly thereafter, he had a gunshot wound in his hand, and he lied to the hospital and to the police, and his lies were inconsistent. He said that he was shot at a Super Bowl party in Palmer when he told the hospital personnel. When the police arrived, he said he was shot at a Super Bowl party in Springfield. So there was abundant evidence against this defendant. There are no further inquiries on that.
As to the felony murder, is it your position that you can keep the felony murder and keep the armed robbery conviction?
Yes, because he was found guilty of multiple theories. He was also found guilty.
Would you have to dismiss at least the felony murder part of that first-degree murder and just stand on the premeditation and the?
Right. The defendant was seeking to dismiss the armed robbery. He's not entitled to a dismissal of armed robbery.
Okay, but aren't you then required to dismiss, assuming you prevail here, the felony murder part?
I'll leave that to the court's determination. He was found guilty under all three theories.
But I mean, it's a very simple question. How can you sustain a felony murder conviction if you have got, if you don't dismiss the armed robbery? You may want to have the armed robbery.
Right, but we could keep the armed robbery because he was also convicted of the deliberate premeditation and extreme atrocity or cruelty. Right. If it was a situation where there was only felony murder and a felony...
You just need to drop the felony murder conviction.
Right. I think that's probably... I did not specifically look at that issue. I'm sure it's a settled principle at this point. But we are entitled to keep first-degree conviction and the armed robbery conviction.
Sure.
I will turn to the Champa issue briefly. The defendant, when he asked for a Champa instruction, it was actually a 5-pronged instruction with 5 enumerated points, and that can be found at pages 10 and 11 of the defendant's appendix. The trial judge gave the defendant pretty much everything he asked for, almost word for word. He gave him paragraph 1, which talked about promises, rewards, and inducements, including implied promises. He gave him number 2, which asked the jury to consider any expected future benefit that Mr. Young may receive. He gave him number 3, which said that it's the jury who determines the bias. He gave him all of number 4, which talks about past favors. And he gave him the second part of number 5, which talks about the jury having to use extra caution, which is a Champa provision in evaluating Mr. Young's testimony. The only part that he did not give was the first part of number 5, which deals with a cooperation agreement. And the judge did not give that because there was no cooperation agreement and there was no truthful component to a cooperation agreement. What Champa required was that if there's a cooperation agreement, that dealt with written agreements, and it's contingent on truthful testimony, if that agreement's admitted and it's for the jury to see, that has to be offset with a special instruction which says that prosecution is in no position to determine whether the person has fulfilled his agreement because the prosecutor cannot determine the truthfulness. That never arose, would never be an issue in this case, because there was no agreement before the jury that it was contingent on truthful testimony. And for that reason, the judge declined to give that instruction. And if you look at the language of the instruction, it would not make sense to this case. It says, the fact that a witness has entered into agreement that refers to truthful testimony does not mean that the prosecution has any way of determining whether the witness is telling the truth. And it also says the promise in the cooperation agreement adds little to the truth-telling obligation. These This is language that is tailored to a cooperation agreement that is admitted in evidence that has a truthful component. And to offset that, our instruction would be required in those instances. It has no applicability, as the trial judge rightfully saw, to this sort of case.
What did the jury know about the arrangements, if any, between the witness and the Commonwealth?
Well, they knew that all of his charges were dismissed, and that was done. They weren't left hanging over his head. And he was given a one-way ticket out of here. And the cost of
That he was flown back, right?
he was brought back, and the cost of the plane ticket was approximately $100. And that was the extent of it. Mr. Yen wanted the charges dismissed because he was fearful. He was fearful not only if he were convicted of those charges, he'd be considered a snitch in prison, but he was also fearful that he wanted to leave the state immediately, and he didn't want to have to come back to face those charges. And they're mostly district court charges. There's one superior court, intimidation of a witness count.
Is what you have just told the court also before the jury?
That was all, yep, that was all before the jury, Mr. Yun's testimony. Unless there's further inquiry from the court, I'm willing to rest my brief.
Thank you, Mr. Townsend.
Thank you.